Welcome back to Big Law University, where we don't sugarcoat shit and we sure as hell don't handhold dorks through law school. We train killers, legal killers. No tuition, no mercy, just straight fire from the front lines of real case law. So today's hit is Cox versus Glenbrook Co. And we're going to hit the facts and we're going to hit them fast and hard. So pay attention. There's a fancy-ass resort in Nevada. That's Glenbrook. Okay? Very important player in this case. And next door to him is Henry Quill, who owned a big piece of property with zero road access except through Glenbrook's land. That is how he would access the land there. So what happens is Glenbrook gives Quill an easement. And if you watch the previous video, you would know what an easement is, but I'm going to tell you again anyway. It's a legal permission to use, in this case, to use their roads, and as quote, as now located. Sounds very simple, sounds very easy, you might be thinking, until one day it wasn't. So what ends up happening in life, Henry Quill dies. He's dead, he's gone. Boo-hoo, you can cry about it later. The property then changes hands a few times, and then it lands on the lap of a new player, which is Mr. Cox here. But Mr. Cox isn't looking to build his single house and sip lemonade like your average Joe Schmo. Nah. He wants to subdivide the land. So he wants to break it down and subdivide it. Build a neighborhood. And this guy wants to widen the road, the original easement road, so that two cars can pass at the same time. Basically, turning this private driveway into some sort of suburban freeway. And Glenbrook, he flips out. They sue, screaming, "That's not what we agreed to." So here's the issue that was presented before the courts. Was Cox legally allowed to widen that road even though the original easement only granted access over the roads, again, as quoted, as now located? So here's the rule of law. Pay very close attention to what I'm about to tell you and take some notes. If you hold an easement appurtenant, that means it sticks to the land, not just a person, as compared to an easement in gross. Again, we discussed that in the previous video. You can use it as long as, one, you're doing what the original parties intended, and two, you're not putting an unreasonable burden on the land that you're using. So I'm going to break that down very simple in layman terms for you people. You can't just go from a quiet driveway to a 4-lane freeway unless the original deal said so. So what did the court say, you might be asking? Subdividing the land like Mr. Cox was doing, that's fine, that's allowed. The easement runs with the land, so multiple people can use it. So if this is you, and this is your friend, and you guys are all living in that subdivided land that Cox, subdivided, you guys can all use that easement. Only if it does not create some sort of nightmare for Glenbrook. It has to be reasonable. So that road widening bullshit that Cox was trying to accomplish, hell no. The easement said, again, as quoted, as now located. And at the time that the original easement was granted, at the time, that road was just a tiny ass one strip lane. Now imagine it if it got doubled, right? That's where the court draws a line and says you can maintain the road. You can maintain it like a reasonable person, like a responsible person. You can level it, you can fix it, you can smooth it out, the whole 9 yards. But you don't get to reinvent the damn thing just because you're thinking bigger like Cox was. So what's the conclusion? If you inherit an easement, you need to respect what the original parties agreed to. You're not some god, you're a guest on someone else's land. And if you overstep, the court will slap some common sense into you. This is Big Law University, where real law students such as yourself, real hustlers, and legal warriors come to turn case law into combat skills. Miss this, and you'll be the next dumbass getting sued for overplaying your hand. Mr. Big out.